So why don't we get started? Continue to grab food in the back, but for those of you who don't know, my name is David Wilkins. I'm the faculty director of the Center on the Legal Profession, and this is our weekly series in which we bring really outstanding practitioners and academics and other people who are interested in the changing legal profession to come and spend an hour with you, talking a little bit about what they do, and then really engaging with you in a dialogue about your questions. I'm particularly excited today because we have my dear friend, in fact, I consider him my Chinese brother, Jingzhou Tao, or Tao Jingzhou, who has been just an absolute terrific guide for me in learning about China. I, as some of you know, am working on a big research project which is called Globalization, Lawyers, and Emerging Economies, or GLEE as we like to call it, after the popular TV show, but I won't sing, I promise. And that project is really trying to understand just what it says. How is globalization reshaping the market for legal services, with particular reference to the important new emerging powers in the world, of which obviously China is maybe the most important. And so we have a project there that's about in the midpoint, maybe even a little bit beyond the midpoint of being completed, in which we are looking at everything from the changing role of large law firms in China, to the growth of in-house counsel, to how legal education is changing, cross-border transactions, pro bono and corporate social responsibility, a range of topics. And in working on this project, Mr. Tao has been absolutely invaluable in helping us to think through how to proceed on that project. In fact, we were just talking today about a survey of general counsels in China that we're about to embark on. Will help us in terms of how to put that survey project together. I'm not going to say much more about him, except that he is, at the moment, the head of developing the China practice for Dechert, a major law firm here in the United States. But as you will soon find out, he's worked at many major law firms here. He's worked in Europe. He speaks many languages fluently. He is one of the leading arbitrators in the world and one of the most influential lawyers in China, and part of the famous law school class that began in 1978. So he has an absolute wealth of experience, and I know you came to hear him and not me. So I introduce to you my Chinese brother, Tao Jingzhou.
Thank you. Happy to be here. So when I come to Boston, David said maybe you want to come and talk to some of our students about the legal profession in China, because a lot of students will end up to become a lawyer, either in local law firms and or international law firm based in Beijing. I didn't really prepare any set of speech, but I managed to talk about the three issues about the foreign law firms. First is the past, and then to talk about the present situation, then eventually talk about the future of foreign law firm, if there are any future for foreign law firm in China. Talking about the past, I think there are two pasts. The first part is really underground existence of foreign law firm in China until 92, and then the official existence of a foreign law firm since, I think, October 20, 92. When I come back to China in September 91 for a law firm called Goodell Brothers, which does not exist anymore because that firm was went down in August 2005, already 10 years ago. My title was Chief Representative of Johnson & Higgins, which is an insurance broker, because you cannot be Goodyear per se vis-a-vis the Chinese administrations, except one, which is a tax office. We have to pay tax as Goodyear Brothers, but for all other things, we pretend to be insurance brokers or representative of industrial companies. Then comes in April 92, the Chinese government say, for many years, we know all these law firms are there somewhere in town, but they do not have an official status. Why not try to regulate them by publishing a regulation? So since April 92, Chinese Ministry of Justice and Chinese Administration for Industry and Commerce have jointly prepared a draft regulation dealing with the foreign law firms. This regulation was eventually published in July 92 with a lot of amendments, which we try to lobby to see whether we can enlarge our activities in China. For example, initially, foreign law firms can only advise on the law of their jurisdiction where they have a partnership. So we talked to the Ministry of Justice saying that, look, we are international law firm. We have a lawyer licensed in many jurisdictions. Why you want us only give advice on New York law? For me, I trained in France. I have nothing to do with New York law. So eventually that regulation was amended on many grounds based on the advice we give to the Ministry of Justice. On 20 October 1992, Chinese Ministry of Justice has issued 12 licenses for foreign law firms, 4 for really foreign law firms, and 8 for Hong Kong law firms. So we were lucky because Goodyear was got the #1 license by accident, because a lot of among the foreign law firms, everybody wants to be the #1. So we try to manage so that the guy in charge of filling in the forms went home to do the job. At that time, there are no mobile phone, so even minister cannot reach him. So he filled in quietly. Afterward, he called me and said, "Okay, you will get the #1 license." So that's the past unofficial existence of a foreign law firm, which ended up in October 20, 1992. After that, there are a lot of law firms try to apply. That at the unofficial stage, there were many 4 or 5 foreign law firms: Goodyear Brothers, Baker McKenzie, Paul Weiss, Graham James, and maybe 1 or 2 British. After Tiananmen event in '89, there were only 2 law firms survived, which were Goodyear Brothers and Baker McKenzie. And Paul Weiss and the leadership of Jerry Cohen decided to pull out of their office from China as maybe a gesture to show that they are happy with what happened in Beijing. So up to from October '92 up to now, until last year, there were over 250 foreign law firms opened their office with 330 representative offices. Some of law firms, they can have office both in Beijing and Shanghai. That's why you have 200 some law firms, but you have 330 representative offices in China. So is a very big crowd now in China. And I don't know how many foreign law firms in New York, really. Certainly China is an important place for international law firm. This development is really matched with the economic development of China for the last 20-some years. And you cannot pretend to be an international law firm if you have no office in China. You should have at least one. But some people have two because you have to wait 3 years before you can apply for a second license. And if you want a third license, you have to wait another 3 years to apply for the third license. So that's the now the development of foreign law firms. But for the last, ever since the economic, financial crisis in 2008, we saw quite some law firms try to reduce their size in Beijing and Shanghai. For example, one law firm from California area, their office in Shanghai was reduced more than 50%. And another law firm I used to work, they reduced maybe 80 or 90% of their size in Beijing. This not only because the financial crisis, so there are much less foreign investment in China. It's also because at the same time, Chinese law firms become very good, competent, aggressive, and they also try to hire quite some partners from the international law firm, and a lot of students like you studied in the U.S., get a GD, and back to China, and because of the profitability concern of international law firms, so those students joined local law firm and become a major competitor of the international law firm. So the work of foreign law firms are still remain somewhat the same. General corporate work for multinational companies, capital market work, IPO in Hong Kong, New York, and international litigation and arbitration. Those are the major work for international law firms ever since early 80s. Then for the last 10 years or so, international law firm also got some work for outbound investment of Chinese companies, for some litigation, commercial litigation, or white-collar crime in different parts of the world, and also in some developing country like Africa or Latin America for the natural resources of those countries. So you see that there are some kind of shifting from traditional joint venture corporate work into a more outbound work in one hand, antitrust, white collar, etc. So I think the nature of the work somewhat changed, and the joint venture work, the general commercial work, seem to be a very low end of the legal work, and all this work are kind of either shifted to the local law firm, or they are handled by their in-house legal staff. For example, for the last 20 years or so, one of my clients, when I started working with them, they have no legal staff in China. Now they have 15 legal staff in the China offices. And some major international companies, they have a very big in-house team. That's why Professor Wilkins said they have to study this phenomena of multinational companies expansion plan in China, which is a very, I think, become a very, very important provider of legal service. Of course, they are, the way of handling this are different, but you see that a lot of routine work are kept in-house because of their cost concern, because international law firms tend to be more expensive, although not always, but having a major in-house department, they can cut their cost. For the future, I didn't bring my crystal ball, so I can just tell you a little bit of my view as to what will be the future for the international law firm. I would say that there are one strong force which needed to be exercised by US government and the EU government for the legal market in order to keep a place of international law firm in China. You know that the local bar always try to, to see whether they can increase the local, legal service provider versus international legal service provider. And also, Chinese government is very concerned of, foreign law firms, the very existence, because, foreign law firms tend to be more aggressive to, defend the interest of their client. So they have no incentive to really liberalize the legal market for foreign law firms. And then come to the, the US and the EU, because on the first at the WTO negotiation stage in 2001, they already, pushed a little bit to give foreign law firms, some, additional scope of service. But now, with all kind of negotiation, free trade zone, bilateral investment treaty, etc., I think they try to also push Chinese government whether they can, whether foreign law firm can get additional service to be provided. But unfortunately, legal service is a teeny part of the overall negotiation. So you need a really international law firms to really lobby U.S. government, USTR and others, and EU Commission, to see whether legal service can be more free in China. So if we do not have this kind of a push from outside, superpowers, I think international law firms' business will shrink, maybe shrink dramatically. So that's why we, in China, we have a different working group among international law firms to to have the knockdown events in DC and in Brussels, try to check whether there are more freedom of exercises for international law firms. And then come to the second question is how we can really make Chinese law firms and international law firms working together. So what kind of joint venture, what kind of profit sharing scheme we can work out with the local law firms so that we can have a more deep footprint in China. Those kind of cooperation existed already since many years. For example, you have this McDermott model, which is the local Chinese lawyer will set up the local law firm, and they have an agreement with an international law firm to have a kind of a profit sharing scheme by agreement. And vis-a-vis Chinese government, they are local law firm. And but they have the more or less the same name than international law firm. So they do not call themselves McDermott, but they call them abbreviation of three words. And this model initially will get criticized by a lot of Chinese, Chinese law firms, and also carefully, examined by international law to say, okay, should we follow this model? Is that sustainable? Is that stable enough to move in that direction? So this is one model. And second one is to have this strategic alliance. Some are official, some are not official. For example, Guantao have one with Evershares. This kind of no exclusive, but pretend to be strategically allianced model is somewhat used by quite some international law firms. Then you have which are already disputed, I think. You have some foreign lawyers based in Beijing. They join the local law firms. They have a Chinese name in one hand, but an English name, they will put some of their partners' name on top, so that vis-a-vis the international companies, it look like international law firm, but vis-a-vis the Chinese government, it look like a local law firm. So, but this joint venture, I would say, would really not work out. So now they already changed their model. And then you have this Kenwood Medicine using a structure in Switzerland, Swiss variant, and have not really a single profit center, but a different profit center. This, another model. And finally, we discussed with Professor Wilkins, there's a Dechert and Denton model, which were reported widely in the international press, because this partnership, if we can call partnership, will have 6,500 lawyers, which is much bigger than any law firm in the world. So either foreign law firms are going to stand alone in China with a lot of challenge, unless US and EU can push Chinese government to get a concession, or you go for a partnership with a local law firm. And in Shanghai Free Trade Zone, the regulation clearly allow the cooperation or joint venture between Chinese law firm and the foreign law firms. But we will see how it goes, because so far there are no law firm followed the Shanghai Free Trade Zone model to set up their operation yet. So we think that in the long run, you still have a place for foreign law firm, but not for 250 foreign law firms. Maybe for a handful, say 50 or some foreign law firm only, or others must either reduce their size or go for partnership with a Chinese law firm, or simply to close their door. So with that somewhat pessimistic remarks, I think I will stop here and take your questions if you have any. Thank you.
Please. So, questions? Just raise your hands. Yeah, here.
Hi, thank you so much for the speech. Actually, I have two questions. The first is, I know that during the past 10 years, like I said, that especially the inbound transactions, the market is more and more dominated by the local firms. So, from your perspective, what areas of practice in the long run will still be dominated, or the foreign law firm can have the advantage. For example, like as you said, FDPA or outbound transaction plan. The second question is, like as you said, we see that this year Dechert had alignment, a merger, like kind of merger with Dechert.
We're not sure what it is. That's why you're having trouble.
I'm curious that working in a Chinese law firm, would you like the best friend strategy with foreign law firms? So I wonder, like for the strategy, like Dechert and Dechert, we see a lot of problem about like the quality control or how you share with the corporation. And another thing is because currently the foreign law firm is highly regulated in China. So do you think such kind of alliance can do all the work like which can be done by the Chinese law firm in practicing law in China market?
Okay, thank you. So what will be the cake left for international law firm? I think sometime for some institutional client of the home office, they still prefer to work with the representative office of that law firm, because if legal service is really personalized, it's a really personal trust. So that's why, although it's maybe higher, the legal fees maybe 30 or 40% higher, they want to buy assurance to make sure that they will have a good partner to deal with the matter. So you still have some traditional legal work remain with the international law firm because of their home office connections. So this one, I think, will still survive. But once they come to the market, once they discovered the service provider in the market, or sometimes when they compare the quality of that law office with other local law firms, they may change their mind. They may say, okay, why should I work with a small, teeny international law firm while I have several hundred, very talented, individuals that can provide me with a comprehensive legal service? So they may change their mind. So that's why for some law firms, they can, because one or two clients push them to go, and when those clients become mature, service, service buyer in China, they change their mind, and there's no place for this law firm. That's why you see some law firms, they have to go, get out of China. For the Dechert and Denton, I think personally, when I see Dechert from distance, it's not really a partnership. I think it's a more national franchise, of service providers. So now you come with Denton. I would say that I think it's a much loose alliance than Baker McKenzie, for sure. And they certainly have no profit sharing scheme. Whether they will cherry pick some Dechert partners as Denton's partner in the international partnership is a question mark. How they are going to do really, it's too early to tell. But as to the conflict of interest, do they have really a comprehensive conflict of interest check? And it's a question, because already within Dechert, traditionally, they come across quite some instance where it's clearly a conflict of interest, but since they are not the same partnership, therefore they didn't care too much. But they may have future professional liability if they use the same brand with Denton and others. So it's still, I think we still have to wait to find out more intelligence about the Dechert and Denton alliance in order to see how, whether it's going to survive, or whether it's really maybe 2 or 3 years alliance, just increase their visibility of both firms, and then they will die out with the time.
Yeah, in the back.
Good afternoon, Mr. Tao. My name is Xiaowei He, an LLM candidate Your speech is always so inspiring. As we all know, you are an international renowned arbitrator in China. And I have two questions. The first one is, what kind of role can international law firm play in the arbitration market of China, even though they cannot present Chinese clients in litigation? The second question is that I'm very interested in the speeding up of CTAC, because now the Shanghai and Shenzhen changed their name, adopt an independent procedure and list of arbitrators. So I would appreciate a lot if you can provide some in-depth and insider's view on the CTAC split up. And thank you.
Okay, thank you very much. Thank you for attending my class on Chinese arbitration in Tsinghua. It's one of the, I think, 3 LLM programs in the world specialized on international arbitration. One in Miami, another in Geneva, and third one is in Tsinghua. We try to make it right, like to try to compete with Miami and Geneva for international student as well. So what's the place for a law firm in the arbitration field? You know that before China published this regulation in '92, it's foreign law firm can do everything as to the international arbitration in China. There did not exist any kind of restriction. So after '92, still there are no restriction. Only after China became a member of the WTO, then the question came out, is that arbitration? Is that a kind of local legal service or not? In some country, their court and their government think that anything to do with arbitration is not a practice of local law. Singapore used to qualify the arbitration as local legal service, and then they abolished this. So Chinese now come out saying that it's a legal local law service. And when this come out, the first one who really try to lobby against this are Chinese arbitration institutions, because they know if you say it's a local legal service, since the arbitration is managed by the party, eventually managed by a lawyer who drafted this contract, if you say, okay, it's a legal service, you cannot do as a foreign law firm, and since most of the contracts were drafted by international law firm, so we pick Hong Kong and Singapore, or ICC or AAA. So that's why the Chinese arbitration institution said, hold on, we'll try to lobby Ministry of Justice to make sure that they will revise their regulations. So they somewhat revised by saying that arbitration, if applicable law is not a Chinese law, you can do. Because, for example, a lot of international service contract is a CISG, the Vienna Convention. So if it's the Vienna Convention, so you can do the arbitration as a counsel for one party. There are even one case in which the Chinese lawyer tried to set aside that word because I was counsel of one party. He said, okay, he is a foreign law firm, and the Chinese law they cannot do, but this was not successful because we have on paper also a local law firm. So in Chinese arbitration context, you always try to put both the name of international law firm and the Chinese law firm, even though Chinese law firm may only do 5% of the work. But if it's Chinese law, you want to make sure that another party are not going to harass you because of these regulatory restrictions. Also, these regulatory restrictions does not apply to a law firm which does not have a presence in China. If a foreign lawyer, you shifted somebody from Boston, they have no office, they go to China, go for the proceeding, since the Ministry of Justice regulation dealing with the presence of a foreign law firm's representative office, and this Boston law firm have no representative office, so supposedly it's not applicable. So we told the Ministry of Justice that said, why you bother? Because why you give us a hard time while we committed to Chinese market, while some other guys can come in to do the arbitration. So that's the short answer. As to the split of CTAC into Shenzhen, Shanghai, I call this in 2012. You had this split into 3 different institutions, and I used the word called Three Kingdom. In the Chinese novel is Three Kingdom. I said the Three Kingdom of Chinese arbitration. So I wrote an article about this in different press. Basically, it's a kind of a fait accompli. So it's already done. They have a different regulations, and the Supreme Court already published some judicial interpretation to deal with such a split. I think you are in pretty good hand now, at least, so that you will not have one arbitration award set aside because one party can allege that Shanghai Arbitration Institution, for example, does not get a delegation of power from Beijing to handle the arbitration cases because they had such a split in 2012. So it's no issue anymore, but you can read my article, I think, called The Three Kingdom of International Arbitration, of Chinese Arbitration, sorry. Yes, this gentleman, yeah.
Just to follow up on the international commercial arbitration, so how receptive in general are Chinese firms, especially state-owned enterprises, to this kind of new international arbitration? And what do you see this market going forward in 5-10 years?
Arbitration is a bargain. So when you discuss a contract, you have this what we call midnight clause, which is arbitration clause. Then it really depends, for an international company, whether they have a sufficient leverage so that they can pick a neutral place, such as Singapore and Hong Kong, for the future arbitration. So some people are successful. Some other companies think it's not that important. We can't have arbitration in China. So overall, I think you have a sufficient argument to say we wanted to have a neutral place to handle arbitration. And Hong Kong, in any event, is China. So therefore, maybe to pick Hong Kong as a neutral place will be an acceptable solution. You can sometimes even compromise, saying that the arbitration will be conducted in Chinese in Hong Kong. So maybe sometime the Chinese company will be ready to accept, because in China, arbitration is not that independent and impartial. You do have some kind of influence of local officials, etc., on the procedure side, if those 3 arbitrators are not strong enough. So you can have arbitration, but if in China, but if you have 3 very good arbitrators, it doesn't matter whether it's in Beijing or in Hong Kong. Sorry.
Yes, my name is Jizhen, and working with Publicans now and business scholar. So my question is actually about the career path of the Chinese lawyers in a foreign law firm. Since you are the most experienced advisor on this topic, so we saw a lot of recent high-profile moves, like even high partners moving from top foreign law firm to a elite Chinese law firm, like the Freshfields partner moving to Bangda. So, will you consider such a move? This is the first question. And second question is, how would you give advice to senior lawyers in the senior Chinese lawyers working in the top U.S. or British law firms. Would you advise them to go to the Chinese law firms like Fangda, like King and Wood? What's your what would be your advice in such a situation?
Yeah, right. Thank you. Yes, well before Kudera collapsed in 2005, at that moment, there are quite some local law firms try to, get me, try to run their international expansion plan. But I said, no, I don't think I will go to any local law firm. Maybe one day set up my arbitrator's chamber, but not go to local law firm. So career path of Chinese qualified lawyers in the international law firm is different. I think there are no set rule, and each law firm is different. So you have two situations. One is Chinese lawyer who also get a foreign qualification. Another one is the Chinese lawyer that have no foreign qualification. So if you are a Chinese lawyer with foreign qualifications, you can eventually become representative or chief representative. And also some law firms think you must get foreign qualification to become a partner. And if you only have a Chinese qualification, since we cannot practice Chinese law, so this does not count for their partnership track. I kind of bridged this in the Kudera time even by make some local qualified lawyer as a partner. So you really have to, because most of the foreign law firms in China are loss center, not a profit center, so their bargaining power are very limited. And if you have a vibrant and profit office in the whole network, I think maybe it's easier to make one or two partners, even they only have a local qualification. So it's we are in a law firm is in big business, so the law firm will take decision based on the sound business sense. So I would think that a lot of Chinese qualified lawyers, because of the restriction, for example, you cannot file antitrust review with MOFCOM, you cannot handle the discussion with NDRC for antitrust investigation. So they think their kind of rule are very limited. So that's why they want to move to Chinese law firm. Then they can have a direct contact with the various Chinese organizations, government bodies, and also they can appear before Chinese court. As a foreign law firm, we cannot appear before Chinese court. So for litigators, they said, why should I stuck with the foreign law firm? I have to work with another local lawyer to do this. I want to do by myself. And also, I think in the Chinese law firm, the profit sharing scheme are very good for each individual partners. So they have very limited overhead, and they also have very limited head office, cost allocated to the local office. So therefore, if you have a profitable client basis, you want to go with the local law firm because where you can keep 50% or 60% or even more of the fee generated by you, while if you stay with the international law firm, I think it's roughly like 35% as a maximum. So, from a financial standpoint, a lot of good lawyers prefer to go with local law firm. So the reason I stay here is because we want to serve the large companies. They have multi-jurisdiction issue to resolve, and it's kind of a high end of legal service. So you say, okay, are you going to work only for money, or you are going to work not only for money but also for somewhat proud to handle some interesting cases. So it's a personal choice, I would say. Yes.
Hi, I'm now an LM student at Harvard, and I'm not looking for jobs in China. And when I look at those international law firms in China, I found that they're really homogeneous. Because of the regulatory restrictions, their practice areas are really focused into several parts, so there are not many options for me. Many law firms only have MA and capital markets. So as a managing partner of a China office of an international law firm, there are certainly some competition among these international law firms. So if all the international law firms are doing the same businesses, how to survive, how to gain advantage over other international law firms. One of the trends that I observed is like many international law firms have become very labor intense. Lawyers in these law firms are really working very long hours, so as to compete with other international law firms. So do you have any way to advise these international law firms to come up?
I didn't quite understand your question, but the international law firms' work are somewhat limited, but I think, as I said, they change also in nature. And now a lot of international law firms try to focus their future business on the Chinese companies for outbound work, outbound M&A, and outbound litigation and arbitration, or capital market in New York and Hong Kong. That attempt was not that successful so far, but I'm kind of confident that with the anti-corruption campaign in China of state-owned companies, this kind of business will pick up. Because in the old days, quite some state-owned companies prefer to work with Chinese law firms because they can have kind of a kickback or other arrangement, while foreign law firms with FCPA and very strict internal control process, we cannot get into this kind of scheme. So they work with local law firms, and local law firm will hire somebody who have nothing to do with China, for example, in England, with second-tier law firms. So they can have a special arrangement. Now with anti-corruption campaign, with a more kind of a process within each companies, I think Chinese law firms' role in such kind of outbound work will reduce and will leave the place to foreign law firm to for the legal work. So for somebody who studied here, you can be a very good interface between local foreign law firm in China and the office here in the States, so that you understand what's the desire of Chinese companies for, and you also understand the local law here in the States. So these are maybe the future area that for law graduates such as Harvard should think whether you can try to be specialized in this area, both on the corporate side, capital market side, and litigation arbitration side. Litigation is in the large sense, product liability, IP, infringement, etc. So those are I think the future, somewhat good future for international law firms. Yes.
Thank you. I'm also from Harvard Law School program, and my name is Lan. I have a question about your specialty, international commercial arbitration. I know that a lot of Asia Pacific branch of involved with more states' interests. And what do you think about the perspective
For the BIT arbitration? Yeah.
Especially for Chinese practitioners involved, Asia-Pacific office of international firms and local firms?
Yeah. I think 10 years ago, there are questions like this to say, okay, since China received so many investment, you must have a lot of cases in which foreign companies are going to sue Chinese government at the exit or ad hoc, but normally exit. But up to now, there were only 2 cases happened. I said, it's not a really good business for us because I'm not going to represent a foreign company to sue Chinese government. If I do this, I should, be ready to leave the country. So the only thing I can do to represent the Chinese government, for the exit cases, which we are on the list, the preferred counsel list of MOFCOM to do this, and they will have very few one, because all the major companies, they are not going to use exit, because I call this administrative revenge of Chinese government will prevent them from taking initiative to sue Chinese government in exit. What they can do is, by this bilateral discussion between government, or they can do with the WTO, where is government versus government. So the company will behind this to do the work. So for the BIT, you will have a lot of Chinese companies who are going to sue foreign government. You have one already in Latin America. You have one where Chinese companies sue the Belgian government. You may have more in African countries where the local government are not really do the rule of law, based on the rule of law. So I think, but for this, the local Chinese law firms rule are very limited. So although it's a Chinese company involved, but it's involve the local law in that country and the international law. So they tend to use the international law firm for BIT. So I think on the BIT front, foreign law firm will have a role to play to represent foreign Chinese companies for the exit arbitration in Washington D.C. And also we hope we will have a role to play in representing Chinese government for the defense of the case in Washington D.C. Yeah, this gentleman, question. Maybe last question, or?
No, we have one question. I'm just going to, anybody who hasn't, we'll come back to you, but anybody who hasn't had a chance to ask a question. Let me ask you this question while then we'll see if we'll
repetitive
get else to think. What do you think the role of the Chinese companies, the Chinese law firms, is going to be in the outbound investment, and maybe not just investment, but the outbound movement of the Chinese companies, and not particularly in the West, but in places like Africa?
In Africa, Chinese company hardly need lawyers.
So far.
You're right.
Right?
Yeah, so far, right?
That is
yeah,
true. So
that's
far.
true.
Yeah.
And it happened that once they come to see me, because they have a contract to sign next day, French document, they said, can you have a read, and we are going to sign only $1 billion investment in the mining sector. So I read this, I said, okay, you can sign, but tomorrow you can come back because the money will be disappear. You give money, you can come back. So we drafted the contract, and 6 months later, they're still, in discussion, because the Chinese company has this attitude of, corrupt local officials, ministers, and president, then get a deal done. And when the government change, they have no really solid contract basis to sue the government. So I think for the local law firms' role in that outbound work, they certainly have a very big role to play because, again, it's like a U.S. company come to China. They want to discuss with their traditional lawyer. And for those Chinese companies, they may also want to discuss with their traditional Chinese law firms to accompany them for the African venture. So I think with this international alliance of Kenwood and others, they may say, we have local presence, like medicine, they have a strong Australian presence. So of course it makes sense for Chinese companies to work with Kenwood to go to Australia, but to Africa, there are very limited international law firms presence in Africa.
Although Denton's is one.
Yeah, right. So
That's what
maybe with Dechert and Denton, that's maybe somewhere they want to focus to prepare for the future, maturity of Chinese companies in dealing with African countries on a solid legal basis versus pure, political and diplomatic protection. That's something maybe I think Chinese law firm will have a role to play.
Okay, yeah, I was trying to get the rest of the chance, but go ahead, please.
Actually, you said currently most of the foreign law firm lost money in China, and we observed that British Frank actually this year have decided to quit Asian market by closing their Shanghai and Hong Kong office. But I noticed that except the competition, another issue is how you deal with the Chinese state, especially state-owned companies. For example, the fee payments, the Chinese companies are reluctant to pay the New York rate to the foreign law firm, so that's why a major reason why they need to quit the Asian market. Besides, I have friends working in foreign law firms. They sometimes complain about the domestic companies because they are not treat the lawyers as a professional. They want the lawyer to see them in their office, not go into the law firm's office. So first question is, how do you think the fee payment this thing will change in the 5 or 10 years? And second, what's your view about dealing with the Chinese companies? What's the difficulty?
I think Chinese companies are getting more and more mature, and they understand the New York rate, and the highest one is the London rate. London rate is higher than the New York one. So my billing rate is higher than 95% of my partners in the U.S. So they get used to, but since the Chinese are good business people, so their in-house counsel are not the exception. So they always try to say whether you can give a discount. Like they go to shopping in the luxury brand, they also try to get a discount. So normally you have to give some kind of a discount, 5, 10, or 15%, so that they feel that vis-a-vis their leaders, they say, look, I get a good bargain and we get a discount, which is good. So symbolically, you have to give a discount, but at the end of the day, I think they are better payer than Korean companies for the last 30 years. So I had a lot of difficulty in dealing with the Korean companies, but very few difficulty with the Chinese companies. Yeah.
So on that optimistic note, please thank.
Thank you very much.
And for those of you who are interested in these issues, we will be continuing to work on the project here. For those of you who are still going to be here, or even when you go back to China, we're very interested in having you stay involved. Thank you.
Thank you.